Good morning, everybody. I have Nazarena very anxious about why I'm not starting on time. Let's see. I don't know.
Hi.
Oh, hi.
Running a little late.
I'm not exactly running late. It's 9:01, actually.
What are we talking
But
about today? Did we pick a topic?
we did pick a topic. Well, I did. I was kind of all over the place because one thing that I was thinking about talking about today, I had this phone call with this older woman, and she was married for like 30 something years, and she never it was like a kind of traditional marriage situation, old school kind of situation where she really didn't know much about her finances or like what was going on with her husband's finances, but he earned like a lot more than her. So anyway, like last November, he like hands her a piece of paper and is like, "Here, sign it." So she just signs it. And are you there? Are you frozen? Is it just me? Am I here? Hello? Oh no! Now you're back.
I don't know what happened, but it was very funny. Are you here? Am I here? Are we here?
Is anybody here? I don't know what we're doing. Anyway, so this woman like signed this document, and the document says, I waive alimony, I waive half the house, I waive any interest I may have had in any accounts, I waive the 401ks, like I just give all of it away. And I was like, this is so crazy, but it's not the first time that something like this has happened. And I was reflecting back on like all the times that somebody has shown up with this document, like, oops, I signed this. So I originally had thought that we were going to talk about that. But then when I was sitting in court, I heard a judge make a comment that I posted that got a lot of traction. So instead, I just decided we would talk about that today. So the other topic, and the reason I bring up the other topic is because I posted about it, like as though we may discuss it today. We'll talk about that next week. So for today, what I put up was about a comment that I heard a judge make in court, which was basically like, I am going to grant an entitlement to attorney's fees because the other party has been attempting to get this information from you since last August, and you've been telling me repeatedly that you're going to get it to me, and I still don't have it. So I'm granting entitlement, and I'll reserve as to the determination of fees. And when I heard the judge, this was not for our case, by the way. I just happened to hear a judge say it, and it made me start thinking about that. And I started thinking also about a situation you've had recently where a person's bad behavior resulted in sanctions, which is when we talk about like attorney's fees, costs, sanctions, there's a lot of different varieties of things that go into it. So I thought we would break some of that down today, like how often it occurs that a judge would say you're entitled to attorney's fees, but I'm going to reserve on the amount. I think people would be surprised about that.
Yeah, and I think that it's important for people to know that there are multiple different ways that attorney's fees can be granted, right? So one of the ways, which is the one that I more times than not get asked about, is when someone is making less money than the other person, right? So we have attorney's fees that can be awarded when there is the need of one person to receive those fees and the ability of the other party to pay them. So for example, the story you were just saying about this woman who for 30 years has never worked and he makes the money. When she goes to court, one of the requests she can make is to have him pay for her fees. Now that can look a couple different ways. So that can be he has to pay for the fees she's already paid, or there are times that we can go to court and do kind of like an estimate of what we expect, certain fees and other costs, right? So it's not just attorney's fees, but if you explain to the court, listen, these are going to be our attorney's fees. This is what's projected based off of A, B, and C, right? We're going to take depots. We're going to do this. We're going to do that. But also you can include in there any other professional costs. So for example, the cost of a forensic accountant. So those are different things. And you can also
or guardian ad litem.
Guardian ad litem, like all kinds of different fees that you can say to the court, this is what we expect. He has the ability to pay. She has the need. Actually, you reverse that. First, you have to find that one person has the need and the other person has the ability to pay for that. So that's one situation which I get asked about a lot, which is, can I get attorney's fees? We can never, guarantee it. But in cases where one person makes substantially more than the other, we at least make the request, and chances are you may get some or all of your attorney's fees paid.
Yeah, so you guys who listen to me regularly on here will have heard me talk about need and ability all the time, because that's really the focus on attorney's fees. But there is this other kind of exception or other way of getting attorney's fees, which attorneys will often talk about as like Rosen fees, right? That's the language that they'll use, but it's really like fees for bad behavior is what it comes down to, right? Like, if you are so difficult, you are not listening to court orders, you're not following through with discovery requests, you're just causing litigation, creating chaos, then you could also be responsible for Rosen fees. And, the things that pop in my brain about that is like, I had a case where one of the parties had filed in Broward County, and while the case is pending properly in Broward County with no issues about venue, the other party filed the exact same case in another county and got temporary relief orders in the other county where venue was also proper. Like, doing those kinds of things is creating delay, it's creating litigation. And that's not based on need and ability. That's based on, like, you have bad behavior, right?
Yeah.
And that happened in your relocation case, right?
Yeah. So there are so many different ways that can happen. So, one of the things that the court can do is sanction a person. And that doesn't always necessarily mean attorney's fees, right? So attorney's fees is one way that you can sanction a person for bad behavior. Another way is making them pay for other things, right? Certain costs of transportation. So for example, if someone relocates without court permission, one of the things that the court can do is say, well, you relocated, you weren't supposed to, you didn't have permission, so now I'm going to sanction you in a number of different ways. One of them being you're responsible for all travel costs associated with your move, transporting the kids to and from to see the other parent. So there's lots of different things that you have to be careful. And this is one of the reasons why I worry when people start doing things on their own without attorneys, right? Because, if you are constantly filing motions that have no legal basis, you're filing the same motions over and over again, you're setting hearings, you're not following the court's procedures, right? Because every judge has different procedures you have to follow, and you have to go onto their website and read about them. Whenever you are not following the rules and not following the law, that can subject you to attorney's fees and sanctions of other sort. So it's one of those things that you have to be very careful if you're trying to navigate this on your own, is that if a judge sees that you are just doing the same things over and over again and you're not listening and you're not following the law, you could be sanctioned. And, our judges say frequently, I will treat you as you are an attorney, right? You're choosing not to have an attorney. I'm going to treat you the same way I would if you didn't have an attorney. I'm not going to give you any special, benefit because you're pro se. So you have to be very careful when you're filing things.
Yeah, and attorneys can be sanctioned.
Mm-hmm.
It doesn't happen very often, but it can happen. And kind of tying into one of the other things that I had thought about for this week, which you just tied into a little bit, is one of the things that you've been working on right now is the family law litigation workshop. And it's interesting because that really is more for attorneys, like it's for our boss ladies business. But I was thinking about that this morning because so so many of the people that listen to us here on Family Matters or who are interested in the do-it-yourself stuff, a lot of the content, I mean, that's sort of why we ended up with these two different businesses, because a lot of the content really is good for attorneys that practice family law, and it's good for someone who's doing this on their own. So I just wanted to mention to you guys that the same content that is good that we make available to attorneys is, you know, tailored and changed around a little bit to make it make more sense and make it more easy to implement, but it's the same stuff that's available to you guys about this kind of stuff.
Yeah, and especially for my litigation course. So the Todd's texting. The litigation course that I'm doing, my goal is to do 4 hours. I'm up to about like 3-ish right now. I have to finalize it in the next couple of days, but the reason it's so bulky is because I am doing like the basics. Like I am doing, these are the different steps in a trial. Yeah. This is how you introduce evidence. This is, you know, these are the words you need to say. This is how you need to dress. This is how you need to direct yourself to the court. Like it is very, very basic for our brand new attorneys, you know, attorneys who have never had a trial, who are fresh out of law school, who are doing their first family law trial. So it's going to be a very good course. I'll probably be done with it in the next few days, and it's going to be 4 hours of just I have a whole other section on evidence, right? So objections. A lot of times when you are a pro se person, you don't have an attorney, you don't know what objections mean. Yeah. And then you could just say objection, 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 causing unnecessary delays. You're not understanding what's happening on the other side. So I agree with you. I think it's a very good course for anyone who's trying to represent themselves too. And we can break it up into different packages, right? We have the 4 hours. We can break it up into the evidence package. So yeah. I think it'll be very helpful.
Yeah, I think one of the things that from this conversation that we should think about and do too is to have a portion of it be about motion practice, because that's what you were talking about here. And it's one of the things that comes to my mind with sanctions and attorney's fees. I am a guardian in a case right now, and there is a guy that represents himself, and he is endlessly filing motions in this case. And the thing is, every time he files a motion, I have to read it. I have to look up the things that he talks about in there, right? Like, it's not like we don't get a choice in doing that, or that we do get a choice in doing that. And every time it's stuff that, like, as a lawyer, I know it's not legally sufficient. It's not going to get anywhere. There's no way he's going to be successful. He can't be legally successful, but it's so time consuming and so costly for these people. And those are the exact kind of situations that if you are representing yourself, you definitely want to avoid, so that you stay out of that loop of getting assessed attorney's fees or sanctioned for bad behavior.
Yeah. And I wanted to touch on something you said earlier about the different venues, because I had a similar case, and I actually think it's different from the one you just mentioned, where there was an entire litigation occurring in a different county. But there were orders in that other county that literally had already been ordered in Broward County. And I think that people think, well, you know, this judge isn't fair. I'll switch judges. I'll do this. I'll do that. And maybe they think no one will find out, but that's not the way it works, right? Like, you can find things out that are happening in the various counties. And one of the things it makes me think about is a lot of people think that they can bounce from one judge to another in the same county. So that is another way that people I have seen have caused this excessive litigation, which is, it's very specific what can happen, what needs to happen in order for you to remove a judge from your case, right? You can't just pick and choose. So what I've seen is people filing, the most I think I've ever seen, which is wild to me, is a case that I've seen. It's not our case. It's a case that I've been following otherwise. 13 different judges have touched this file.
Oh my God.
13. And then you're like, well, we don't even have 13 judges in Broward County on the bench. Like, what happened? They had to get judges from other counties to come in, and it was ridiculous. And it's a crazy case where this person just keeps, causing litigation and causing issues and causing the judges to recuse themselves. And eventually one of these isn't letting go, and he's getting slammed with attorney's fees. So you just have to be very, very careful.
We should do a live on getting judges removed on disqualification, because I think people are super, like, I almost went off on a tangent and then I stopped myself. There was a question in the comments about whether there would be any material on, I'm assuming they mean an order to show cause and how to present an order to show cause. I'm not sure that that's already in the litigation material.
It's definitely not in the litigation material, because for me, it's just very basic, right? I think that's a little bit, a different route, a little bit more advanced when you have those kinds of things. Mine is like, what's an opening? What's a closing? How do you present evidence? What can you say? What can't you say? So the litigation course that's going to be up soon is just very, very basic, but that's the first one, right? Like, we're going to have other ones, and that's not a bad topic that we can discuss for a little bit.
Yeah. All right, guys. Well, that is what we were tuned in to talk about today on attorney's fees. Well, hold on a second, because before we stop things, we didn't really answer or talk about what I posted about, which is when judges say that they're going to award fees, but they're going to defer on the amount. So that's something that happens really often in family court. That because you will ask the judge for fees based on some particular thing, and the judge may determine, yeah, I think you're entitled to fees, but I'm not going to tell you exactly how much, because a lot of times we end up having a whole hearing to determine what the fees are. So do you want to talk about that for a second?
I can. But something else that happens also is not just the hearing on the amount, but also a lot of times what seems to happen is the judges wait to the end of the case, right? Because this is likely not the first time it's going to happen, right? So one of the things that I've seen judges frequently do is that they'll award fees, they'll reserve on the amount, and then they say, we're going to address it at the final hearing, right? And I think part of that's because they expect there to be other issues they need to assess, not necessarily just on that side, but both sides. But so, for example, if the attorney's fees were awarded, right? So the judge finds that they were entitled to fees, but then they have to reserve on the amount and figure out how much it is. If you're having a whole separate hearing for that, one of the things that has to happen is the attorney has to produce invoices. So, for example, if we were awarded attorney's fees, I have to come into court, show the judge all the invoicing that I have done on this file relative to that issue, right? It's not going to be like everything I've ever done on the file, but it's what did I have to do as an attorney? What did I have to bill my client for to deal with this bad behavior? And one of the things that the judge has to do is determine that those entries, the time entries, are correct, accurate, appropriate, right? We go through all those things, make sure it's related to this. And as the attorneys, we essentially testify. We say, these are my fees, this is what he did, et cetera, et cetera. And then once that is assessed, you add it up and a fees amount is awarded. So one of the ways that it could, there's lots of different things, right? So one of the things that you can do, just in relation to the question that's in the chat, one of the things that you can do is that you can show the judge that this person has funds available to pay, right? So one of the things, and I know I'm like all over the place, but it's like so specific. So we can get mandatory disclosure, right? We're allowed to get, in any family case, the financial documents of the other person. So as an example, let's pretend that the person who is engaging in the bad behavior has a checking account with $100,000 in it. Well, it's easy for me to be able to show that to the judge and say, well, judge, he's sitting with $100,000. I'm asking for $10,000 for my fees. Obviously, I'm asking you to pull it out of there. So if you can show that the person has money from somewhere, a source that they can easily get it from, then that's part of what you demonstrate at your fees hearing, is to say, look, I'm entitled to X amount and he has it sitting in this account, or he can get it from this other location. So those are things that ideally you would try to. However, if that is not readily available, that money, one of the things that can happen is that there can be a judgment, such as what was just discussed in the chat, right? You get a judgment, you can get a charging lien. There are certain things that you can do. You can hold on to a lien on somebody's property, for example. And so there is a problem with the title on that property and you need to get paid before, right, it gets sold or something like that. So there's a lot of different ways, and each case is very specific. So we'd have to see what's available to say, what can we do, right?
Yeah.
But ideally, you would be able to show, look, it's sitting here in some account. Or if, for example, if it's, let's say, a divorce and you're going to sell the house as part of the judgment, one of the things you can do is say, well, judge, instead of it being equally split, I want to get more from the sale of that house because I'm entitled to this amount of money. So there's different ways to slice the pie. You just got to be able to show the judge where the money can come from.
And we do usually prefer to get attorney's fees dealt with through uneven distribution of assets and debts, rather than to have payment plans on them. But you sometimes will have payment plans that happen as well. All right, so that was that. Thanks, you guys, for tuning in. Sorry, this early Sunday morning for attorney's fees. And I'm going to try to remember for us to tune back in next week on the conversation about settlement agreements, because I think that that's also a really important one. All right, bye, everybody.
Bye, guys.
Happy Sunday.